Welcome everybody, happy to see you, even though at least here in the room we are a smaller group, but we have online participants as well. And I'd like to welcome everybody to the last Law After Lunch lecture in this semester. Of course we continue next semester, and we are going again to Africa. We had last week an overview presentation on the African Continental Free Trade Area by Professor Marcos Merso, who gave us an insight into the historical development and the structure of this very ambitious economic integration project covering almost all African states. We learned already last week that the main treaty is supplemented by additional protocols, one of them being the investment protocol to the AFCTFA, and thus an important development with regard to, as it is called, Africanization of investment law. We have the honor, and we are very happy to have Marta with us. She is assistant professor at Addis Ababa University. Marta Hailu received her LLB from the Addis Ababa University as well. She's teaching there, as I said, and she's teaching international trade and investment law. In addition to her LLB studies at Addis Ababa University, she received a master's degree in LLM from the University of Western Cape, South Africa, and moreover a PhD from this university, the Martin Luther University Halle-Wittenberg. She researches and publishes on African regional integration. Her PhD thesis is on free movement of labor forces in Africa in regional trade agreements, migration, development, Ethiopian investment treaties and laws, and also Ethiopian secession on the World Trade Organization are subjects she's covering both in teaching and researching. Marta, we're happy to have you here, and the floor is yours.
Thank you very much. I see a little bit, people are not much today, too many people around here, but it should be okay. Thank you for a wonderful introduction. I was asking, is it me or someone else? Thank you. So my topic is on the investment protocol of the African Continental Free Trade Area, which is part of the treaty establishing the African Continental Free Trade Area. This document was recently adopted in February 2023 summit. There are some provisions which are yet to be again finalized because of a reservation from a couple of countries. So I will skip them. And my point here in this presentation is to show how this protocol somehow tries to address the concerns of African countries, what we call the Africanization. When we see the participation of African countries in investment treaties, we have different bilateral investment treaties, more than 800 signed by African countries, out of which around 500 something are in force currently. But many of these bilateral investment treaties were concluded with capital exporting developed countries. Of course, there are also BITs with other African countries. Aside from that, there are also other international investment agreements, which contain, for example, regional economic community treaties, which have investment provisions. But of course, while we have this kind of participation, signature of and entry into force of those treaties, particularly bilateral investment treaties, much of the time the African countries were passive in a sense. They were rule takers instead of rule makers. They were subscribing to what is presented to them by the other counterpart. We find even less participation when it comes to the use of or people being arbitrators in international investment arbitrations. And then there is this belief that these investment treaties, particularly the bilateral investment treaties, they protect the foreign investment excessively as opposed to or compared to the protecting the interests of the African governments or the nation as a whole. So the whole debate of how can we make this better to the state, how can we regain, how can the African states regain the control of their relationship with the investors and better align the investment laws, the investment treaties with their other interests of sustainable development and so on. So this issue started to be debated in the late 2010s, and then that is what we are talking about when we say Africanization of investment law. So making African countries look rule makers, not just rule takers. And we have seen changes across the years, both at the national level, countries adopting laws trying to reflect their interests. At the reg level, we have the COMESA investment agreement, we have the ECOWAS investment agreement, which tries to address those concerns. And then now at the continental level, under the investment protocol of the CFTA. So what are these innovative measures which try to align the interests of the African governments to, or the African states rather, to the investment agreements is, one is in the objective, we have inclusion of broader objectives. Not just the treaties or this investment protocol particularly is not only about the investment protection, but rather additional broader objectives are included both in the preambular statements as well as in the objective provision of the protocol. So the emphasis is given to the contribution of investment to sustainable development, which basically includes poverty reduction, human rights, how we can further the respect for human rights and human development. And as a whole, one chapter is devoted within the protocol for sustainable development matters. And then we have also a focus on investment facilitation. So it's not just investment protection, but rather investment facilitation among the African states. And we have also an emphasis on balancing the rights and obligations of state and the investor. So it's no longer only the protection of the investment and the protection of the investor, but rather also the obligation of the investor being included as an objective of the protocol as well. And then we have also another approach, which is limiting the scope of investment, what investment is within that protocol. I'm sure you know about the Salini criteria, so investment is defined to fulfill all those four criteria, which includes contribution to host sustainable development. So that is one important thing. Again, the investor is required to maintain substantial business in the state, in that state party, to get protection under the protocol. So of course, it can be defined or it can be determined on the basis of the amount of investment that is brought and the size, scope, and so on. We have specific things are provided in the protocol itself, which would say that this investment actually is a substantial business within the state. And then you have also exclusion of investments which are not considered to be central to developing state economies, like, for example, portfolio investment, debt securities, and so on, are explicitly excluded from the ambit of being considered as investment. When we come to substantive legal protection, yes, as an investment protocol, as an investment treaty, it gives protection to investors and investments, but it tries to limit the type of or the kind of the ambit of the protection that it gives, either by excluding some things or by providing clarification on what a particular thing means. Like in the case of the MFN, for example, it expressly limits the application of the MFN to only to substantive matters, and it doesn't extend to procedural dispute settlement procedures. That is specifically excluded. In the case of national treatment, for example, what constitutes like circumstance for national treatment to be there is also somehow clarified. We have to look into the effect on local environment, the community, the health, and the aim of the measure in question have to be taken into account to determine likeness of circumstances. Again, coming to fair and equitable treatment, the protocol excludes fair and equitable treatment, and instead it has a provision which says administrative and judicial procedure. What administrative and judicial procedure constitutes are enumerated there. When you look at these details, like fundamental denial of justice, due process, denial of due process, manifest arbitrariness, and so on, those are what are defined to mean administrative and judicial processes. So if you look at this, how fair and equitable treatment has been interpreted by different arbitral tribunals, when we flesh out what constitutes those things, much of the elements that we have here constitute fair and equitable treatment. But the protocol goes to the extent of saying that, yes, I have included those things, but the fact that those are included here doesn't mean that this is a fair and equitable treatment. So when we talk about administrative and judicial procedure, exclude this idea of fair and equitable treatment from the protocol as a whole. And then we have also a recognition of states' right to regulate, specifically provided for in the protocol. So that means if a state wants to take measures in order to ensure or to fulfill the environmental conditions, health, climate action, and so on, including, of course, security interests, then the state is within its mandate to take this, the right to regulate. And the exercise of this right will not give rise to any claim by the investor. So those things are very important from the point of view of the African state, because when we look at it from point of view of also this fair and equitable treatment, how it was defined and so on, there is this understanding that the fair and equitable treatment leads to a regulatory chill, where states may not introduce laws later on, which, even if they are, the purpose of that is to ensure environmental protection and so on. So recognizing this right to regulate basically tries to address that point as well. Introducing investor obligation clauses. So we have specific clauses which require investors to act in a certain manner, not just to observe the law of the country. Of course, any investor working in a host state is expected to abide by the laws of that host state. But in addition to that, there are specific things which are provided in the protocol, which includes the protection of the indigenous people and local community rights, particularly when it comes to their involvement in the investment, the land holding rights of this community. So it requires that there has to be free, prior and informed consent and participation in the benefit of the investment by the indigenous and by the local community. So that's something good. We have also anti-corruption clause, which requires an investor not to engage in either directly or indirectly in some corrupt activities. We have social political obligation, which requires the investor to refrain from interfering in the internal affairs of the host state party. So those things are specifically provided for in a very detailed manner to ensure that the investors observe the other concerns, the concerns voiced by the African people. And then we have also a limit on the use of international arbitration. So we have disputes, investor to investor or investor to state or state to state dispute. When it comes to state disputes, of course, a reference is made to the protocol on dispute settlement procedure. So we have whatever is provided in that protocol. When it comes to investor to state, of course, the first one is consultation, then negotiation, and so on. It's also the diplomatic protection by a home state is also envisaged. But the question is whether or not the investor would have a recourse, direct recourse against the host state, either in international arbitration or to domestic court. That is one of the issues that is left to a future annex, an annex which is going to be negotiated. So not yet. So these are some of the measures, innovative kind of measures, which are introduced in the protocol. But of course, they were also present in some of the bilateral investment treaties, which were recently concluded by this African countries. So what's the next step in terms of actually applying it, actually implementing the protocol, and indeed Africanizing this investment law regime? First is ratification. That would be one of the challenges, I fear, because the protocol again requires that it's required that at least 22 of the state parties need to ratify this protocol. So it's the fact that the AFCFTA treaty has been ratified and has entered into force doesn't mean that the protocol, the investment protocol, or any of the second phase protocols would automatically form part of that. It needs another ratification. Another challenge would be ensuring, which would also be related to ratification, would be ensuring policy coherence. What's going to be the fate of the bilateral investment treaties that these African countries have been signing? So, as far as African states party, the AFCFTA state parties are concerned, there is a requirement that they have to how do you say it? After 5 years following the entry into force of the protocol, then the BITs would cease to exist, including the clauses which would allow the continuation of the protection there. But when it comes to with non-AFCFTA state parties, what is provided in the protocol is that they may consider whatever is provided in the protocol in the future negotiation and renegotiation of this agreement. So when we see the number of BITs that the African countries have signed with the non-AFCFTA state parties, the number exceeds than with their African AFCFTA state party counterparts. So that means an investor considered as an African investor would be at a disadvantage compared to an investor who is from a non-state party, because all those investor obligations that we talk about are applicable only when it comes to the protocol. So that will have some kind of potential, in my view, some challenge over there. But overall, ensuring policy coherence, especially vis-a-vis the RECs, the Regional Economic Communities investment policies, vis-à-vis the national legislations of the state parties is an important matter to cover when we talk about, when we feel like Africanizing this treaty. That's it. Thank you.
Martha, from this inside, questions? So, yeah.
I was wondering, first, thank you for the very interesting presentation. I was wondering, many of the classic standards that we have with most favored nation, national treatment, and fair and equitable treatment are, maybe you could say, a little bit diminished in this treaty. How effective do you think the actual investment protection will be compared to a standard European investment protection treaty?
Yeah, the thing is, we're trying to change the dialogue from investment protection to investment promotion, investment facilitation. Yes, I see the danger, like if it was the fact that none of those legal protections were available in the protocol, of course one may feel that it doesn't give me protection, but the protections are there. It's just that let's make the protection somehow beneficial, not just for the investor, but also for the host state as well. So let's move the dialogue, the focus of the dialogue to investment protection, investment facilitation, and so on. So yes, it's a bit different from what it used to be, but I would still feel that it would satisfy the interests of both the investor and the complaint from the side of the host state.
I was wondering, maybe first, can you again, maybe I missed something, explain what the scope of application with regard to obligations of investors is? Who is obliged under that? Which investor?
The investor.
Yeah.
The investor has to be an investor of the AFCFTA state party.
And one of the, so, okay, then I understand. And that only for investment, obviously, once the treaty entered into force.
Yes.
Okay. What is the rationale behind this? Excluding third-party investors from being obliged under the treaty?
To begin with, they are not beneficiaries as well, not just an obligation. But even for the benefit, to get the benefit, also they are excluded. This document is between the FCFTA state parties. So they are the ones who are supposed to benefit and to... but of course, when you see who is an investor under the protocol, particularly when you talk about corporations, what matters, who controls the corporation does not really matter. If, for example, the shareholders are from Europe and the company is set up in Kenya, for all FCFTA practical purposes, it would be a Kenyan investor. So ultimately, of course, what the shareholders, being Europeans, would benefit from the protection as well as the obligation provided there. But because of how it is defined, how an investor is defined in the protocol.
And those obligations, for the moment, I'm interested in the obligations. Those obligations are direct obligations under the treaty towards the investor.
Yes.
That is to say, you do not need the state as a contracting party in between, as an intermediate, but it's direct obligations. Which I'm asking that because it's quite unique. And it's new to have direct obligations in such a comprehensive way as you described it to us on investors, direct from public international law on the investor, because that means the investor is a subject of international law under the treaty.
Yes, but even when it was talking about only about investor protection, the investor is again subject of public international law. Is that not the case?
Disputed. Normally, majority says, for example, the German Constitutional Court says that the investor has not direct rights, but the rights are transformed by the state, because it's only states that are contracting parties to the treaty.
But then when there is a dispute, particularly with the use of the exit, for example, the investor...
It's taking only up the rights of the home state, but not individual rights. And investment tribunals have, let's say, a split opinion on that. We have maybe, I don't know, 15 or something like that, investment tribunals who dealt with this question, and they're half and half. One half is saying they're direct rights, the other half is saying no, they are rights of the contracting states, and thus the investor is only taking up the rights of the home state and bringing them as rights of a third party, of the home state, to the tribunal. So this is, in this clarity, it's new. Yeah.
I don't know how to respond to this. Maybe if Marcos, if you can help me.
No,
Because he's been there.
It's an interesting, it's truly, from an academic perspective, very, very interesting development. The only parallel with regard to investor obligations, direct obligations we have is international criminal law, where we have direct criminal law obligations in this regard on the individual. Otherwise, we hardly have this. So
I think I didn't look at the exact article yet, but in most cases the protocol is drafted in such a way that it requires state parties in their domestic law to apply certain obligations.
that's exactly my question. That's exactly
So
my question.
I don't know, Marta has been working on it recently, but most of the obligations are really to be incorporated in the national law. And then most of the provisions also say in accordance with national law, as provided in the national law. So
yeah, that's what I guessed, because that's therefore my question. So yes, the question is, are there direct obligations under the treaty on investors?
I doubt it. My perspective. But you know, Marta.
Yeah,
Probably I'll have to check again, but I haven't seen a provision which says in accordance with the national law of the state party. Unlike other protocols, where you, like the movement of persons protocol of the AU basically says in accordance with the national laws of the state. But this one, probably I will have to check again, but I haven't seen such a phrase there.
makes, of course, a big difference.
Yeah.
Another further question, if I may, is why exclusion of portfolio investment? And is that flatly any portfolio investment? Or, I mean, if the taking over by stocks of the majority of an enterprise. No, I'm not talking about the disputed portfolio investment cases, like where we have a very tiny minority share, something like that. But big money, so to speak, but not in terms of operating directly on the green field. So is there any differentiation? Is it
Yes,
just
those
any
those that do not have significant contribution, like in terms of the shareholding and so on, so less than a certain percent, not specifically provided what should be the share percent, but we have the phrase there is those that do not have substantial contribution to the development and so on of this.
So portfolio is included, but there's a certain threshold, so to speak.
With the understanding is that when you say portfolio within that, it somehow excludes only those minorities, yes.
Okay, that makes sense. And thirdly, you mentioned that already in your presentation, but I would say this exclusion of fair and equitable treatment is not an exclusion. I mean, what you showed to us, the definition of what is understood and what is protected with regard to administrative and judicial procedure is exactly what tribunals have adjudicated so far under fair and equitable treatment. So the only remaining issue maybe is
protection of legitimate expectations. Okay, but we have excluded that under FET, also in other treaties already, CETA and so on. But anything else is FET. It's just, that's political symbolism, I would say. I mean, it's only not using the term, but the clauses in it. From what I learned, would say.
Yeah, and again, probably it's more of to make sure that the clause is interpreted or defined in a limited manner. So when we talk, like, you only think of administrative whatever procedures, and then you see only due process, whether or not there's a lack of due process, and so on and so on. That would confine it to some extent. So the whole problem is that's how the FET was interpreted, the understanding that it's been interpreted to incorporate so many things. And that has created some kind of uncertainty on the part of the government.
Yeah, that's a political debate. But again, I would say this broad interpretation of FET is exactly what has been described by you with regard to administrative procedures, because the very large majority of investment protection cases, in the ISDS cases we have, are on administrative procedure. So more than 90% of all case law we have on FET is on administrative procedures. I would say that's it.
We don't call it FET, it's something else, so it's okay.
Yeah, that's politics. But it doesn't change the law, I would say.
So, Marta, you mentioned that there are already a lot of BITs between the African countries, bilateral or even multilateral. So how does this fit in? Is it like an extra? Is it like a catch all right? If the others don't apply, then we apply this protocol? Or maybe you can explain that.
So for the BITs, we then signed between African countries. Hopefully, let's say the protocol enters into force in the coming 2 years, hopefully. So within 5 years following the entry into force, the BITs among African states they will cease to exist, including the survival clauses. So that means at the end of the 7th year, they will not have any bilateral investment treaties among themselves. And then even in the future, they cannot conclude bilateral investment treaties. But the problem is when it comes to the outside, like with regard to other non-state parties. So we don't apply it, like, for the protocol to be applied, first of all, the investor must be an African investor. Forget who controls or who owns the share of the property there, but because that investor is registered in that state and have a substantial business going on in that state, that becomes an African state, that becomes an African investor. So the protocol would apply only to this person. There's no way a corporation which is incorporated here in Germany, doing substantial business here and so on, but making an investment in Ethiopia, for example, trying to get the protection from the protocol, because the protocol does not apply to such persons. But the problem then is, of course, the BIT between Ethiopia and Germany would give much protection to the German investor, but not so much to the African investor. That is, of course, one of the concerns, the challenge that we see.
But that would lead to the fact that fewer companies that are outside of Africa would establish big branches in Africa, right?
Yeah.
So they would stay with their main focus outside of Africa, so not to fall under this.
That's a challenge, I would see. But again, how about the other protections that the investors would get?
Okay.
Just go ahead, please. Go ahead.
Yeah, thank you. So
My knowledge of international trade law is almost next to nothing, so excuse maybe if my question would sound ignorant. The issue of recognizing the state's rights to regulate, what isn't it an inherent power of the state? Why is the motivation behind it, other than maybe excluding, as you say, the standards of fair and equitable treatment, or what's the motivation behind restating the state's right to regulate?
It seems that when only you talk about the protection of investment every now and then, and again, it seems that you are forgetting that there is an inherent power on the part of the state so it's all about the security, somehow creating some kind of sense of insecurity among the different African countries. It's not just limited to Africa, by the way, those things. When you look into the recently concluded bilateral investment treaties by the developing countries, like Brazil and so on, we have these recognitions, these things, recognizing the mandate of the state to regulate. So the whole point is to avoid any confusion, to ensure that you are within, as for telling the investor that yes, you work here, but make sure that you're working under our laws, and we want to reinstate that every now and then.
We also have a question from the chat. Christina asks, can you explain how the right to regulate not giving rise to a claim will work? Of course, the right to regulate is a sovereign right, but typically it is disputable, ? In the sense that a whole state assertion of the right to regulate can be challenged in arbitration proceedings.
I have the same question when I follow up. You said if a whole state is exercising the right to regulate, no claim is possible. What is it, exercising the right?
Like, for example, if you're taking a property or imposing a high amount of fine for a violation of the environment, violation of the human right, kind of thing. This is what I would think of. So, of course, there has to be a balancing to be done, in a sense that we have to see when you look at the specific provision there, we have to see the purpose of the measure and the effect of the measure to determine whether or not this was regulatory, whether it is the government is within the mandate to take such a measure or not. So when you recognize that right, so probably takes us back to the previous thing, the FET, where it is more of a political statement, telling the government, the state, that as long as the measure is comparable to the effect, the purpose, and so on, you can take such a measure.
Which essentially then means there isn't anything new, if I may say, because that's what tribunals today do already. They balance legitimate public interests towards protective rights of the investor.
Yes or no?
Yes. It could be politically wrong, but yes.
But I have one question with regard to being rule takers and rule makers. I'm a bit aware of the indigenous people's perspective from the African states, that even now many of them are very hostile to it. So the inclusion of the word indigenous as a standard, indigenous people, I mean, they would say, we'd be willing to accept the criteria of, free, prior, and informed consent with regard to, affected people, local communities, okay with them, but this category, conceptual category of indigenous people, it doesn't apply to us. That's the kind of standard position of many African governments. Now that they have included it in this protocol, does that really make them maybe still it's some kind of maybe rule borrowers, not really rule makers? I don't know, it's just maybe outside your scope.
Yeah, this is, we're talking about indigenous people, so I honestly don't know how we can look at that. like within, for example, within the confines of Ethiopia, if you talk about indigenous people, like what do we mean? This is, I really cannot understand it because everyone is from there. So would that really make sense for us, including that thing? Is so this is an area which I'm not that much aware of, and I would rather not say anything on that.
Good. You see chances that in Africanization, that an annex on ISDS or whatever kind of dispute settlement we will see, or is that the end for now of the negotiations, and then maybe in 10 years we come back to the issue?
He's more appropriate to probably to say because he has the information, but you know, we have some strong countries who are advocating strongly against SDS, and then other countries who want to be the hub of arbitration and advocating for SDS, and it's something that we'll have to see how it will unfold. We have those two strong countries, yeah.
Marcos, any additional comment? We have to see. Okay. Thank you very much. Very interesting.